Do you know the difference between domicile and residency? Well, owning a home in Florida does not automatically provide a Florida domicile, and getting this wrong could affect your taxes, estate planning, and homestead protection. If you're thinking about making Florida your permanent home, there's an important distinction between being a Florida resident and establishing Florida domicile. Residency generally refers to when you're physically living here. You may own a home in Florida and spend several months here each year while still maintaining legal and financial ties to another state. Domicile goes considerably further than residency. It is the one place you consider your true, fixed, and permanent home, the place you intend to return to when you're away. Simply purchasing a Florida property does not automatically establish domicile. Your actions should consistently demonstrate that Florida is now the center of your personal and financial life. It's also important to eliminate conflicting claims of residency in another state. Establishing Florida domicile is especially important when applying for homestead benefits. In order to qualify for the current property tax exemption, as well as civil liability protection, you must own and occupy your home as a permanent residence as of January 1st, and apply with your county property appraiser by March 1st. The key is consistency. Your home, identification, tax records, voter registration, and legal documents should all tell the same story, that Florida is your permanent home. It's important to understand that Florida does not require someone to live in the state for a specific number of days before declaring Florida domicile. Domicile is primarily determined by two things. First, physical presence in Florida, and secondly, a genuine intention to make Florida your permanent primary home. The commonly cited 6 months and 1 day, or the 183-day rule, is not a Florida requirement for establishing domicile. However, it is often relevant because a person's former state, particularly a state with an income tax, may treat them as a statutory resident if they spend 183 days or more there. Someone leaving a high-tax state should consult a Florida attorney and a tax advisor familiar with the former state's residency rules, because declaring Florida domicile does not automatically prevent the former state from challenging the move. In summary, in order to declare domicile here in Florida, there are some steps that you must take. First, obtain a Florida driver's license or state ID as soon as possible, and be sure to book your appointment in advance because appointments in your area may take weeks. Number 2, file a Florida Declaration of Domicile. Obtain and complete this form provided by your local clerk and circuit court. Sign it in the presence of a deputy clerk or notary public and present valid government-issued ID, and of course pay the recording fee, which is nominal. It's between $10 and $20. And it'll take about 30 days, more or less, to get this document back. Now, additional things you have to do are register all your vehicles here in Florida and register to vote as soon as possible. Declaring your Florida home as the primary mailing address is important, as well as updating tax, banking, insurance, and estate planning records. And lastly, you must relinquish residency benefits and connections in your former state. Hi, my name is Amaranth Robertson. I have more than 30 years of experience in South Florida luxury real estate. I help buyers navigate not only the purchase of a home, but the important decisions that come with establishing life in Florida. If you're considering a move or exploring your homestead options, please reach out to me at 305-496-8218. I'd be happy to help you understand the process and connect you with the right legal and tax professionals to make sure everything is structured properly from the beginning.